He doesn't start. It's early. All right, we'll still go over to Lone Wolf since he was hanging out with us. All right, man, 58 minutes. I did this early. You said appeal. All right, you guys are awesome. Lone Wolf doesn't start for about a minute and a half, so you're gonna be in his waiting room for a little bit. That's fine. He he might start early once we all come over there. But you guys have a great rest of your evening. I will see you all tomorrow night at 7. Tomorrow night's yoga night. I think that's about all I have to say. Once again, on let's see, I think it's like May 25th. I will be gone till like I think 4 days. It's like Friday. It's like Monday to Thursday. I think. I don't know. I gotta check the dates, but so I won't be here. All right, that's pretty much all I have. You guys are awesome. Have a great rest of your evening. Till next time, bye.
Thank you, Colin. It is May 13th of 2026, and this is the Court Gallery. Today we witness the raw power of justice as three sisters confront their brother's killer with words that cut deeper than any sentence. Then we pivot to a defendant who thinks a medical card from another state is a get out of jail free card. Spoiler alert, not with Judge Stevens. We'll see a judge's patience wear thin with a homeless couple racking up tickets they can't pay, and we'll wrap things up with a trio of brothers whose chaotic night lands them all in front of the same long-suffering judge. It's been a long day in court, ladies and gentlemen. The excuses are never ending, and it all starts right now.
Okay, going for that again here.
We're gonna do Vice Middleton first. She's being transported to TDC as soon as this hearing is over.
Okay. Yeah,
I've got the family members that want to do the allocation here in the second row.
okay. But we need a defense lawyer, right?
Ryan,
It's Gertz. Are you going to do that for Gertz? Are you going to be for? It's
she's not
Ryan.
saying anything. It's just them getting excited. So if you want to do it, fine. Yeah. Just make sure you tell her she can't respond.
It's just victim impact statements today.
Okay.
Yeah, we've already entered.
Yeah, they've already been sentenced to everything. We're just doing this is just an allocution that they didn't get to have her say whenever she got sentenced.
Mhm.
So we set up as soon as possible, and she's been scheduled to head off today.
Does Ryan know to be here?
Well, Ryan's in trial. I don't know if he knows to be here.
Well,
I
he's
told
in
him
trial
I
here.
told him it was happening, but Ben Jeffries is going to go ask her if he can sit in because it's no advice
Okay.
except telling her to be quiet and
All right. Then
not saying anything bad.
let's work that out. 22-40354 is called the State of Texas versus Lace Christian. Am I pronouncing Lace? Yeah, that's you. And you were earlier indicted by a grand jury for the first-degree felony of murder. And this case has been disposed of. You entered a plea of guilty to the first-degree felony of murder on February 23rd of this year. And then later, this court sentenced you to 40 years imprisonment under the plea agreement on May 4th of 2026. And also in that hearing, the court noted that the judgment would reflect that that a deadly weapon was used in the commission of this offense, namely a firearm. Now, under the rule of law, relatives or close associates of a victim in a case such as this, where it is a violent crime, have a right to be heard, to confront you and express their sentiments concerning this whole matter. Who is here on behalf of the family to speak?
We've got sisters and our sisters.
Okay, what we'll do is, who wants to go first? Let's
Just come on up.
just come up to the lectern there, and
Would you rather all three stand together or go?
these people,
Whatever you guys.
family of the victims, have a right to be heard, and there shall be no rudeness and no remarks made by you. Ms. Christian, do you understand? This is the law. They have a right to be heard, and you must quietly listen. And please tell us your name and how you are related to Russell Rideau.
Thank you, Judge. Good morning. My name is Cheryl Rideau Baldwin. I am Russell Rideau's sister. And I'm just lost. I don't even know this person.
They're talking about the victim.
The victim, yeah.
I'm sorry, the defendant.
Yeah.
Defendant Blaze.
I don't know her. My brother talked to us. He's the kind of guy that called and talked to all the family members. Okay? And he told me about Lacey. And I told him to leave you alone. I told him to not talk to you. Because my parents raised us. And we were raised with respect. And we were raised to not to do the things that you did. But you killed my brother. My brother has a daughter. She wanted to be here today, but she got an auto accident. And it devastated her. It devastated all of us, And I just can't fathom how could anyone that stands in the house and do the things that you did to my brother. I have a brother, Kenneth, who just recently died. You killed him too. You didn't directly, but indirectly. When you killed Russell was Kenneth's way. He talked to Kenneth every day. My brother, Kenneth, needed Russell. Okay, but when you killed Russell, well, Kenneth died right along with him. Because Kenneth didn't talk to none of us. He just went down and down and down and down. You should never see the dead light. Because something is wrong with you. And I don't think you can be fixed. So God have mercy on your soul. But to ever walk out to see or be with anybody, you can't be with the rest of us. Because you're not like the rest of us. With that deviant behavior that you have. You make me sick.
Next, please. Just introduce yourself and tell us how you were related to the complainant, the victim in this case, Mr. Rideau.
Thank you, Jesse.
Yes, ma'am.
Good morning. I am Dr. Laura Rideau Harris, and I am the sister, the youngest sister of Russell. And I wanted to come before you today and look right at you as a minister of the cloth of Jesus Christ, Lord our Savior. And knowing that there's a little girl under all that anger, all that meanness and that terror and that monster that you allowed to be buried. And you did not deal with that as a youngster. And you let that manifest into something horrible, caused you to stand in front of my brother, sleeping on the chair, and just shot him with no one else. And then after you do that, you want to stand around us. You want to stand around us like you did nothing. I tell you, when may God have mercy on your soul. You need to dig out that child inside of you and deal with her. And you need to execute these demons that have gotten you to where you. They divide you up enough The next thing it's going to do is kill you, it's incarcerated you. You in a bondage. You have no idea that the gates that's putting you behind. You are behind some gates that are iron and physical, but you in a separate bondage. And you're going to stay bonded. And as long as you deal with these demons, look at me. Look at me. You better cast them demons out. You better deal with them demons. Because I'm forgiving those, as the Lord told me, if I don't forgive you, don't forgive me. So I have to. But I'm going to put you in God's hands. God bless you.
Lord. Next, and again, please introduce yourself, ma'am, please, and tell us how you are related to the victim in this case, Mr. Rito. Thank you.
My name's Lloyd Johnson. Pastor Rito was my brother. No, any one of us. He was my heart and my soul. I pushed and I pushed to get him better. But please, I hope you've been stewing in your thoughts. I really do. May 10th was made 4 years that you took him away from us. May 10th. And I do remember the day that they told me to come to my mother's house. And you stood right beside me and acted like you were so concerned. And that same breath, you're trying to tell me about my family, who you know nothing about, who you had no dealings with. My brother called us every single day, but for nothing else for a prayer. And all he ever wanted from you was a family. And all those nice little, you got all these emotions now. Remember those when you thought about shooting my brother? Because he was asleep when you shot him. Indefensible. Indefensible. And ladies, you know what? We found this wallet behind the refrigerator, and we know why it was there. Because guess what? He had given you money, and he told you no. He got tired of giving you money for drugs and whatever else you were taking money for. In the name of kindness, his kindness, not yours. His good news, not yours. His love, not yours. All he ever wanted to see was the best in you. And you repaid that kindness and shot him 6 times, point blank in the chest. And then you have the nerve to sit there in the ditch and act like you were concerned. You are a fake sociopath. And I'm glad my sister feels for you, because the human side of me does not. The spiritual side of me says I must forgive. I don't know how to do that. I'm not there yet. I'm not there yet. I ain't never be there. Look at me. Because you're standing. I need you to look at me because you were so concerned. I need to see that concern now. I need to see that love that you sociopath that you put there, when you decided that you were going to shoot my brother. And then come back with, oh, you're so concerned. Love. I heard you the biggest fake. I want you to have every night to think about, and I hope you go to sleep seeing his face. I hope you wake up seeing his face for the rest of your life, which I doubt. Which I doubt that these tears are even real either way. Because if that's for the judge and, John Q. Public here, because I don't believe you. I truly don't believe that you're remorseful. I don't. Every one of us in our house, every single, do not trust you. Every sibling told him, leave you alone. And he thought there was something there to save. He's a Christian man. He came out only wanting help. He thought there was something there to save, Lace. Look at me. He thought there was something there to save. Is there something there to save? Is there? I'm just asking you. You're going to have to deal with that, sweetie.
You're gonna have to go with that. Cause I don't see it. Right now, I just don't see it. I don't wish bad on anybody. But you got 40 years to think about what you've done. And to me, that still is not enough. God bless your soul.
Anyone else on behalf of the family?
No, my other sisters couldn't be here. My brother couldn't be here. They wanted to, and his daughters couldn't be here.
Yes, ma'am.
But that is what that's what you did. You should never see the day of life. You won't ever change. Ever. I don't think you will.
Anything else?
Judge.
All right. Best wishes to your family. And memories are never enough. But best wishes to your family. That's enough. You can take her away. We're in recess. Let's get ready for trial.
I'm putting change.
For the better or worse?
Change. I'll leave today.
For the better or worse? For the better? Make a promise. Change for the better. All right, 25 CR 722 is called the State of Texas versus Jawan Kolar. That's you?
Yes, sir.
And you were here with Mr. Galmore, your attorney and the state's attorney. You have been indicted a year ago for the third-degree felony of unlawful possession of a firearm by being a previously convicted felon. And the court has looked at the probable cause affidavit, also has in reference to the defendant public safety report that it has reviewed from the Department of Public Safety. And what was the original, when he was arrested, what was the original bond? Has it always been $100,000? No, I didn't think so. It went up because he tested positive for tetrahydrocannabinol the other day, right?
Correct.
Also, we had some issues, didn't we, on the monitor?
There
Or it was,
was a charging issue at one time, but the court removed the monitor.
the monitor was for what purpose?
I don't know. That's
We
why.
had monitors for everything.
Right. That's why I filed a motion to remove it because I didn't know
Was
what
it-
it was for.
It was a GPS one,
GPS monitor?
I think, or something, you know.
Okay.
But the court removed that.
Really probably need more in the way of drug patch.
We had the drug patch.
Does he still have that? No, he's been in custody.
No.
But I mean, was that a condition of bond?
At one time, but no, it was no longer a condition of bond at the time, but he was here the other day.
Sir, you're going to have to change your clothes. Or what are you here for? For what court? For this court? For what? No, when that is gets everybody's attention, which it does. This is a court of honor. You're supposed to have decent. Would you wear that to church? Now, we're not church, but it has the same respect. Get another shirt before you can come back in here. I don't want you to have that shirt that's got writing on it and it gets people's attention. Dress nicely, please.
Good. Step
You're excused.
Step outside.
Thank you, sir.
What are we doing? Step outside, sir.
It's not a debate, sir. Thank you. Just dress nicely. That's not hard to figure out. All right. Okay. Go ahead.
Well, Judge,
What do you want?
well, if I skip most of the contents of the motion, skip most of the grounds, and I go back to what we're
Whatever's
asking for,
substantive. Yeah.
what we're asking for is the court to reinstate the original bond.
Why? Okay. Tell me about why there's not a punitive measure that should be placed because of the positive test for meth.
Okay. Well, Mr. Kolar has a prescription for medical marijuana in the state of Louisiana. Louisiana has comprehensive state authorized medical marijuana programs. Louisiana revised statutes 40.1046. I cited it in the statute. It permits physicians to recommend medical marijuana, and they can buy it through the state department through the dispensary. Texas also has a very similar program. It's called the Texas Compassionate Use Program. It authorizes physicians to prescribe THC cannabis to patients as well. Those programs may be independent, but the federal government now recognizes both of those programs. Last week, the federal government rescheduled marijuana, scheduled at Schedule 3, which does allow it to be prescribed. And it also states in that rescheduling Schedule 3 that it recognizes all state medical marijuana programs. So I believe when the court asked me the other day, does Texas recognize Louisiana's medical marijuana program? My response would be under the Commerce Clause.
They may very well.
The federal
They may
government
very well.
recognizes all medical marijuana
My
programs.
issue is what restricts this court from ordering a condition of bond to prevent him from using THC, a controlled substance. Why can't the court have the power to do that, notwithstanding the law that says he can have medical? It doesn't say that a court does not have the authority to make its own rules of bond restrictions, such as restricting controlled substance use, which I intend to do at all times.
The first reason, Judge, is because this court has made no individualized findings to this particular defendant why that condition is appropriate.
It's appropriate for all.
If we'll
when
go
I
back
said
to
it,
my,
it's
I'm sorry, I was
appropriate for all.
making my argument. You asked me to make my argument. I was trying to do something. If you look
And
at Section
thank
3,
you for interrupting. Thank you for go forward.
if you look at Section 3, that talks about how there is actually now legal hemp marijuana in all states. The federal government also recognizes that. If a person uses that, they will also fail for marijuana. But you're referring to the condition that the court has on the general order. Well, it's on the court's website, which basically states that no person who's charged with a crime in Jefferson County District Court is allowed to use any marijuana products of any kind for any reason, at least without prior court approval. Now, there's a lot of problems with that. Number one of the problems with that is that it's a blanket condition that's not authorized by any statute. It's unconstitutional because it's a preset bond that imposes a condition without any individual findings on all the defendants charged in this court. There's a federal case that came out in the last 10 years, which was O'Donnell v. Harris County in the Fifth Circuit, which was all about preset bonds that did not consider individualized determinations regarding the amounts of the bonds. And
I'm familiar with that. All cases should be individualized.
correct.
You
So
don't
a general order.
Tell me that.
So a general order that has a condition that's not authorized by statute is a condition that is not individualized to each defendant that it's being applied to. So it was never individualized to this particular defendant that I'm aware of. I don't believe there are ever any findings made, particularly on the record for this particular defendant. So that's a preset bond condition without any individualized finding to any particular defendant.
Were you saying all of our general preset bond conditions are unconstitutional?
Oh, no.
Because they're in every case.
Oh, no, they're
But
absolutely
they
not.
are in every case.
They're all statutory authorized, Judge. The safety, no communication with the victim is statutory authorized. Do not break a law is statutory authorized.
Yeah.
Travel restrictions, statutory authorized. Those are all statutory authorized. There is no statutory authorization for a blanket, no legal substance
What else?
usage in this county. There is no condition in Jefferson County State you cannot use alcohol as a condition of a bond. The reason is because it's not statutorily authorized,
No.
and it would not be an individualized finding made.
Is marijuana still a controlled substance in this
It
state?
is a prescribable substance.
Is
by
it?
doctor.
I'm asking you.
Yes,
It's not.
of course it is.
Okay.
Yeah,
All
of
right.
course it is. And I don't believe there's a condition right now that states that all prescriptions must be turned into the court. All controlled substances must be pre-approved by the court before getting a prescription. It appears to me the only one is marijuana. And I haven't figured out why marijuana is being singled out different.
It's not being singled
Other
out.
controlled
It's just
substance.
a subject of this issue right now. When I deal with issues when they come up, sir, and this one has come up, and this is a kind of a first review of such an issue ever brought up in the 20 years that I've been doing this. So, and I'm not surprised. Things are always new here, and so we just don't come here knowing all the history of what circumstances can be, because every day we see a new set of circumstances. This court has a consistent decision that it has always made on controlled substances. And controlled substances, when it comes to marijuana, this court has an issue when you are able, without any restrictions, to use a controlled substance to drive a 4,000-pound missile around town, or to function in ways in the free world that require thinking outside of a controlled substance, then the court's going to deal with those issues individually. And a lot of people have prescriptions. Those are controlled substances. That doesn't mean that they can't use that controlled substance. This court is not satisfied that in this particular case, this is an issue that is, nobody's told me, nobody's convinced me that it's necessary for whatever his needs are, and that his needs of marijuana do not adversely affect the general public in his daily functions. And that's what this is all about, is the welfare of everybody else, as well as his rights. But I open the door, and then somebody comes along, and what's good for one is good for everyone. And this court has not been convinced that this is necessary for whatever his needs are, notwithstanding a prescription that may have been submitted to it. And I'm more concerned about the well-being of the general public when people are able to get in a 4,000-pound missile and operate a missile while under, while under the influence of tetrahydrocannabinol of marijuana. That's the issue. Anything else?
Yes, Judge.
Let's go. I've got to go back to a trial.
So, Judge, part of the other problem with that standing order right now, not only is it not individual findings,
it's a standing order for him right now under his circumstance.
Right.
You won't find it written anywhere. When you call it a standing order, let me correct you, please. It's not standing. You're not going to find it anywhere.
It's in the
but under
general
his circumstances, under this circumstance, which is really kind of a first impression for the court, that's what I did.
Judge, General Order number 2023-1 is on the court's website as a standard general order applying to all defendants. So
okay, read it out loud.
Read the general order out loud?
Yeah.
Okay. Well,
what is it? Do you have it?
Yeah, I mean, I cited it right here in my motion. It says right here, the one I'm particularly talking about, it says that no defendant shall use any amount of form of tetrahydrocannabinol, including but not limited to marijuana, hemp, delta-8 THC, delta-9 THC, delta-10 THC, THCV, THC-O, CBD products, synthetic cannabinoids, or any other products or substances that contain or derive any amount of form of THC, unless a valid and verifiable medical prescription is provided and approved by the court. Problem is that by requiring a person to provide medical prescriptions to the court without any individual findings of why that particular person needs to do that, number one, that's a violation of HIPAA. Your court is requiring people to disclose their medical conditions to the court before any findings been made that is somehow relevant to their case. He's going to have to provide who his physician is, the treatment status, his medical condition, the medical treatment plan. All of this is in violation of HIPAA and his privacy rights. There have been findings made in there.
What else?
The other thing I'd like to point out is that the condition, even though it's actually never been applied to him individualized, there's no purpose for that particular bond in this particular case. His case doesn't have anything to do with drugs. His case, he's not been alleged to have been driving on THC. He's not been alleged to have been intoxicated at any point in time in this particular court. The metabolites in his urine will show the marijuana for up to 30 days. He's prescribed marijuana. That's to be expected. So, Judge, what I'm requesting from the court, and Judge, I do need to get the court the prescription. The state's got it. The court's got it. I don't have a copy of it in my hand. And I'm going to have to update the court with the business records affidavit because the pharmacy in Louisiana has not yet sent the business record affidavit for admissibility purpose, but I will make it for appellate purposes, make sure I get that to the court. But we're asking the court is to declare that the blanket THC condition on the general order as applied to all defendants is unconstitutional. It's not statutorily authorized. To remove the THC prohibition from this particular defendant's conditions, because there's been no individual findings that that condition applies to him. Remove.
You've stated that. You've stated that. What else what other relief are you asking?
I'm asking the court to reinstate the original bond amount because the revocation of his bond there's no violation that's been alleged or proven here. The drug test doesn't prove any actual violation. He hasn't broken any laws. He's followed all of the laws, including federal law. And so we're asking the court to release him immediately.
Once again, he tested positive for having THC in his system.
We know that.
Okay, that's a controlled substance.
Is a prescription.
Okay. What does state say?
Judge, the thing that's not been shown is that Texas has a reciprocity statute that says we recognize the medical marijuana card from Louisiana. Plus, the other thing I see on the bond conditions are that there is a way if he has a prescription, but it's got to be approved by the court. And that should have been done a long time ago before he tests positive. And you come up and start screaming foul. Somebody should have come and said, hey, we've got this, and this is going to be a possibility if he tests. And so we need to get approval by the court, and we should have the medical record showing what condition it was, and that it meets our statute under Texas statute for medical marijuana cards. Or he could come to Texas and get something here, but he has to be a citizen to do that. So in order to do that, he'd still have to show that he's in compliance with ours for us to even consider whether we're doing reciprocity, because I don't know what his condition is. We haven't heard anything about why he's taking it, other than he's got a medical marijuana card.
You would have to move here, though.
Anything else? I've got to move forward. Anything else you want to add on?
No, just that we'll have to supplement the record at a later time with some additional.
You're allowed to do that anytime, whatever supplementation you need. He's asking, hold on, Mike. He's asking for reduction. What do you say on a reduction of the $100,000 amount? What was the original amount?
16.
I'm sorry?
16,000.
Judge, we're still going to have the same problem next time he comes in. So
how long have you been in jail?
Since
All right.
he's got the card.
I don't have a problem with some relief on the reduction.
What was your original bond?
16.
16?
16,000, Judge.
That's all.
Yeah, we're all number on.
Okay. The court is going to grant the relief that's requested to pass to 16, but the court is going to, everyone is going to test you, and I'm going to continue. We're going to get this circle back. You're going to have a drug patch. You're going to have a drug patch as a condition of your bond. You test positive, we're going to come back here. I agree. The state, other family, I agree until. I'm not going to follow Louisiana law and the Napoleonic, that's based upon the Napoleonic Code. They have the right to conduct their business in that state. At this state, nothing until this court these laws from this state that give the relief that where you can test positive for THC and without other restrictions to ensure the safety of the community, because THC is illegal, and that does not make the world a safer place when you're able to operate a 4,000-pound missile around town and do heavy construction or whatever it is you do. So you test positive, we're going to come back in, we're going to have another hearing. And until this court can a finding from authorities of higher authority in this state that medical THC allows you the freedoms that everybody else has using THC. This group is not going to put people in. So be careful. And they'll be tested, and if it's positive, come back up, and we'll have to hear another bond issue. Anything else? Here's this. Thank you.
Court does call the case, People versus Angela Stoker.
Look for Stephanie.
What?
Go and look for Stephanie.
What? Stoker.
Ron Brown appearing on behalf of Ms. Stoker. The Office of the Public Defender does not believe a conflict
I don't need
between assignable
prosecutor. I'm good.
Good.
I'm good.
All right. I should
Brought the card today.
report with my client. There's no additions. Or changes to it, correct? Ready to proceed to.
Ma'am, is there anything you'd like to say?
No.
Court, I'll place you on 3 months prosecutor at $50 fines and costs, $90 probation over. When can you pay that?
2 weeks.
Yeah.
2 weeks.
What I'm doing?
$125.
Yes.
How much?
$390.
90.
In 2 weeks?
She'll pay the 120 balance in a month from then.
When can she pay the 390? I don't know how this got complicated.
But she just started a job at Ichiban, Your Honor. You know they held the first 2 weeks.
I'm sorry. What can you pay today? I could pay Friday.
Yeah.
I could pay Friday. Probably 100.
Pardon?
$100 on Friday.
100. Thank you.
You're welcome.
Pay $100 this Friday, which 15th. Well, pay that by the 18th. Give you till Monday to get that in. And then when can you pay the balance?
Within the next 30 days. Is that okay?
Pay by the end of June.
Yes.
Okay. Pay by June 30.
Thank you.
There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete an anger management class as directed by probation. No contact with Cheryl Godfrey Gerstein, directly or indirectly. No assault or threatening or intimidating behavior. No possession of any weapons, firearms, ammunition, or anything fashioned to be a weapon. I'll set a review hearing in this matter for August 12, 2026, 9 a.m. I'll order 90 days in jail. That is suspended.
Thank you.
Thank you.
Have a good one.
Courthouse case, People versus Sharon Abbott.
Sherilyn Foster Tucker on behalf of Sharon Abbott.
Good morning, Sharon Abbott.
Go ahead.
And Your Honor, we have reviewed the pre-sentence report. We do not have any corrections, additions, or deletions. Just ready for allocution when the court is ready.
I'm ready. Go ahead.
Your Honor, we are asking that the court follows the recommendation. I've gotten to know Miss Abbott through this case. I know that she deeply regrets her actions on this day. I did want to let the court know that for the past 13 years, Miss Abbott has worked as a nurse at U of M. With this conviction, her livelihood is at stake with that. And so that is a collateral consequence that she's dealing with this situation as well. In addition to that, she supports her family. Her husband is on disability, so she is the only one working for them. So this has caused a huge financial and stressful burden for her. And then she did write an apology letter to the victim, which she would like for me to read, I believe. And just to warn the court, it is a little bit long. It's about a page long.
All right.
Dear victims of the crime and whom it may concern, I am writing this letter with the intention of acknowledging the harm I caused and taking full responsibility for my actions. On July 25th, 2025, I participated in an act of indecent exposure. I understand that this behavior was deeply inappropriate invasive, and very likely caused you emotional distress, fear, or a loss of trust in your surroundings. I want to express my sincere and unreserved apology for the impact of my actions. Nobody should be subjected to indecent exposure. Nobody. This act was inexcusable. I have a son and understand that as parents, we must protect children from seeing these kinds of acts. This was stupid, inappropriate, and appalling behavior on my part, and I am so deeply sorry that you witnessed this. Going to the pool on a beautiful summer day should be something to enjoy, not something that winds up being uncomfortable, distressful, and harmful. What a wake-up call this has been. I will never forget this ordeal, as it first and foremost has caused you and your daughter harm. Therefore, I have been quite harsh on myself as a result. I believe my purpose in life and my values are centered around helping others, not causing harm or negativity in others' lives. The decisions I made were so profoundly wrong. It is just crazy to me. You should be very angry and upset with me. I cannot express in words how sorry I am for so intrusively stealing your daughter's innocence and confidence in the safety of your home community. I am sorry for how long this has been dragged out as well. My hope is for you and your daughter to be able to heal and move away from this. I take full responsibility for what I did. While I was under the influence of alcohol at the time, I recognize that this does not excuse my behavior. This would never have occurred if I were sober. Alcoholism was a contributing factor, but the decision to drink and the consequences that followed were mine alone. I am accountable for the harm I caused and am so deeply ashamed. I want to assure you that I am committed to aggressively addressing the root cause of the problem to ensure this type of behavior and harm to others never happens again. I understand that an apology cannot undo the damage. I also recognize that you may not wish to engage further, and I respect that. My hope is that this letter communicates my remorse, my accountability, and my commitment to change. If there is a way I can make amends that are appropriate and meaningful to you, I am open to hearing them through this process. Thank you for your time and for allowing me to take responsibility. I am committed to doing better for you, for the community I harmed, and for myself. Most sincerely, Sharon Abbott.
Is there anything else you wish to say to the court? Sentence of the court, 18 months prosecutor deferred sentence. You are to pay $655 fines and court costs, $540 probation oversight fees. When can that be paid?
Your Honor, she can make a payment of half the balance today. And then I believe she needs to set up a payment plan with probation. She's not sure what financial situation.
So when you say half, how much does she have today?
655, 40 divided by.
Go ahead, Foster Tucker. I wasn't going to do the math.
About 600.
I'll say 600 today. Thank you.
You're welcome.
The balance will be as a payment plan as arranged by probation. There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to provide proof of completed substance abuse treatment with UMATs, including all recommended after and to follow all recommended aftercare. You're to continue individual therapy with status reports to probation. There's to be no contact with Mary Beth Mann directly or indirectly. No going to Heatherwood condos in Ann Arbor. I'll set a review hearing that's to be held November 10th, 2027, 9 a.m. Order 365 days in jail that is suspended. Thank you.
Thank you, Your Honor.
Court calls case people versus Emily Burgess.
Good morning, Your Honor. Attorney Jonathan Paul for Ms. Burgess.
Ms. Burgess, can you state your name, please?
Emily Burgess.
Go ahead, counsel.
Thank you, Your Honor. We had an opportunity to read the pre-sentence investigation. Probation did a good job putting together Ms. Burgess's proactive steps since this incident. She's been very active and busy in taking amends and putting her best foot forward. We're going to ask the court to adopt the recommendation. We think it is a fair recommendation that reflects Ms. Burgess's hard work over these last couple of months. We ask the court to sentence her with the opportunity for the deferred sentence and to allow her to continue her progress.
All right. Ms. Burgess, is there anything you want to tell the court before I impose sentence?
No, I just want to say thank you for your grace and your mercy through this process. It's not been easy, but you guys have made things very smooth. I appreciate it.
Sentence of the court, 4 months prosecutor deferred sentence. You're to pay $480 fines and costs, $120 probation oversight fees. When can you pay that?
I can pay it in full today.
Yeah, today. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete a theft class, which you've already done, and it is marked as completed. You're to continue individual therapy with verification to probation. You are to complete 25 hours of community service as directed by probation. No going to any Target stores in the state of Michigan. I'll set a review hearing that's to be held September 9th, 2026 at 9 a.m. I'll order 93 days in jail. That is suspended. Burgess, thank you. Thank you, Mr. Paul.
Thank you, Your Honor. Emily can sign off. I'll follow up in a bit.
Thank you.
Court calls case, People versus Elizabeth Chuddick.
Good morning, Your Honor. I'm Bernstein with and on behalf of Chuddick.
Your name?
Elizabeth Chuddick.
I didn't know that. Go ahead. All right.
Your Honor, I have no corrections to make to the report. I can tell the court that her actions in this process has left her pretty humbled. She's been engaged in counseling over the last couple of months to engage in insight and to learn from her behaviors and how she can move forward more appropriately. Ms. Pilar always puts together a fair and appropriate recommendation, and we ask the court to please adopt it.
Yes. So of course she did.
I told her that personally before I walked out, but
all right. All right. Ma'am, is there anything you want to tell me?
I just want to apologize for my behavior. I am working with a counselor so that to make sure that this doesn't happen again.
All right. Sentence of the court, 9 months probation. You're to pay $555 fines and costs, $270 probation oversight fees. When can you get that paid?
Today, Your Honor.
Today. Thank you. Pay that today out at the counter. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to continue your individual therapy with verification to probation. You're to complete 25 hours of community service as directed by probation. There's to be no assaultive, threatening, or intimidating behavior. There's to be no possession of any weapons, firearms, ammunition, or anything fashioned to be a weapon. I will order 365 days in jail. Credit to the balance is suspended. Thank you.
Great day to your staff.
Same, Mr. Court calls case, People versus Shante Wingard.
Good morning, Your Honor. David I. Goldstein appearing on behalf of the defendant.
Good morning, Shante Wingard.
Your Honor, we have been provided with a copy of the pre-sentence report. We have reviewed it. There are no changes or corrections.
All right. Anything either you'd like to say before I impose sentence?
We're asking the court to follow the recommendation, Your Honor.
Sentence of the court, 4 months prosecutor deferred sentence. You're to pay $480 fines and court costs, $120 probation and oversight fees. When can you pay that?
Your Honor, she can pay half within 30 days and the balance within 60 days. I would point out that she is working, but she has 5 kids, Your Honor. Single parent, 5 kids.
5 kids. Okay. Oh, she's going to feed them too. Okay, fine. Okay, so you can pay half of it in 30 days. Okay. So pay $300 by 15th. That will work for you?
Yes.
By June 15th. And then the balance by July 15th. That'll work?
Yes.
All right. There should be no use of alcohol, recreational marijuana, or any illegal drug. You'll be subject to random testing as requested by probation. You're to complete a theft class within the next 60 days. No going to any Target store in the state of Michigan. I'll set a review hearing September 9th, 2026, 9 a.m., 93 days in jail. That is suspended. Thank you. Bless you. Was that you? Okay. Just checking. Calls the case, Bevo versus James Harris. Calls the case, Bevo versus James Harris.
Roger, I'm appearing on behalf of Mr. Herring, Your Honor. Can you state your name? Your Honor, may I approach with probation? I have something to share with the court.
Yes.
Thank you. My client has a screening and assessment scheduled for May 19th, I believe. I'd ask the court to adjourn to allow him to pursue treatment, if that is what the assessor believes is required for him. I've explained sidebar that he has a part-time job, full-time job, and he also is caring for for a minor child, Your Honor, on Saturdays and Fridays. Tuesdays and Fridays. So, Your Honor, he has a lot going on. This is a case from 2024, and I'm asking the court.
Yeah, but he's been gone at least half that time. That's part of the problem.
He also has a PCC in front of you, and between now and then, if he can get that assessment and get in treatment, I think it would show the court a lot about him. Turning the page on his previous choices.
In August of 2025, to the 24th, he had additional stuff that he picked up between that time and the time he was supposed to come back before me and didn't show up.
He's presumed innocent on those charges. Your Honor.
On which charges?
The disorderly conduct in Hazels Park, where he goes to court tomorrow.
Not saying that. He picked up additional stuff and didn't do what he was supposed to be doing in September. And then I did issue a bench warrant, and we don't see him until April of this year. Meanwhile, he's picked up other charges that he's got to appear before me.
And he's out on bond.
And correct. But then he comes here today and he now wants to show me that he's enrolled in some type of counseling, but he didn't do that until Friday.
That was after the PCC year, because he was in court on Thursday. And he had to make sure that he get a bench warrant issued for Thursday.
Anything else you want to say?
You want to tell him anything?
Your Honor, I've been going through a lot, with my baby mother and getting my daughter and visitation times with her. And, my mother's been coming in and out from Georgia, and like, nobody's trying to work with me. You know what I'm saying? Like, everybody's trying to force me down about this drug case when I'm taking accountability of my problems that I have, trying to get help. But I'm just depressed, man. I was at that. I can't see my daughter. I pay child support. I try to do the right thing by my parents, by her, and to be a successful father. I don't like to let my child down. When I went out there, whenever they locked me for disorderly conduct, it was so many different things that they were trying to put on me that they sit, and they already arrested me, so they couldn't unarrest me. But I was an innocent man. And they said I went into the library.
Don't talk about a pending case. In terms of the facts of it.
It's interesting you say nobody was trying to help you. We've been trying to help you throughout this entire case. You just haven't been cooperating. You decided to do your own thing. And then decide you're just going to disappear and not do anything.
No, sir, I didn't disappear. I've gotten pulled over numerous times, and they said that
you knew you were supposed to be here in September 2025. You didn't show up. You got a bench warrant. You didn't come in. How'd you come in April?
They had a warrant. I got off work.
They picked you up.
Right.
Didn't turn yourself in.
No, I did not.
That's a problem. Because the reality is, had that not happened, you wouldn't be here now. So you can't go around blaming everybody else. At some point, you got to take responsibility for what you do. Sentence of the court, $125 statutory, 365 days, Washington County Jail, credit 217 served. Defendant is to serve the balance. I will consider release upon release to residential treatment at Dawn Farm. Defendant's released. Court calls case People versus Aisha Green Gefford.
Hold on, I'm undoing my video now. Okay. You see me? Okay, hello. Hi, Judge.
Hello. Hello. State your name for the record.
Aisha Green Gefford.
All right, thank you.
Mhm.
All right. What?
Ron Brown appearing on behalf of Ms. Gefford. Your Honor, Ms. Gefford is in nursing school. She's scheduled to graduate in June. Where? Nursing school.
What?
Yes.
I'm sorry.
Wait, tell them the story. Where are you in school? Toledo,
I'm at
right?
Hondros and Mommy. Yes.
Mommy, Ohio. She's going to graduate in June, Your Honor.
Yep, on June 19th.
June 19th?
Yes.
So she owes a little money, Your Honor. We talked about her trying to make a nominal payment and catch.
Is this? Oh, these are both show causes.
Show causes for money.
I'm breaking up. I'm sorry. Can you hear me?
Yeah, we can hear you.
Okay.
Internet in Ohio, but okay, we can hear you. She owes $380 on one case, and
Yeah, and I just spoke with Miss Alexis as well, and she's sending me over some paperwork to fill out about arranging the payment.
Wing and collections.
Yes.
all
'Cause I
right,
had
but you're
contacted her about the
graduating.
balance.
See, this was back in 22. So what, outside of school, what have you been doing?
I go to school 5 days out of the week, so I really don't have much to do outside of school besides homework and getting ready for quizzes and taking my state board.
So
And
you're gonna
taking
be a
care of my
nurse in
children.
Ohio?
Oh, no, I'm a Michigan resident. I just go to school in Ohio.
Oh, she wanted to make that clear.
Oh, very clear. Yes, I'm born and raised in Ann Arbor.
Right? I'm just here. I understand.
Yeah, yeah.
So she's gonna be a nurse in Michigan.
Mm-hmm.
My luck, if I don't do something nice, that all of a sudden I'll show up in the hospital. She'll say, "Remember, Judge?" And then
Well, she still has to take care of you.
she, but
Yeah,
She has
I
a
would
nurse.
never do that.
I don't know.
Judgment yet.
All right. So how are you? So you're gonna fill this out, but when you get out of school, you got to take the boards. Are you working at all, or are you just?
No, not right now. I just I plan on maintaining employment once I graduate from our program. They're gonna help us with getting different jobs and things like that. So I can't see myself not being employed by mid-July.
Give me a. On me. Give me my August date.
Possible.
All right. So on the case ending in 1781, which is the OWI, I'll adjourn the show cause to August 12th,
Okay.
2006 at 9. And that way you don't have to do that. On the other one, did you pay anything on this case at all?
Not yet. I had just started my payment plan, a month or two ago, because I had just got off for probation. I got off early. So we set up the payment plan. And to be honest with you, I have forgot to make the payments. That's why I had contacted Miss Alexis today and let her know what was going on. And she just, sent me the paperwork back. So it's just a matter of me just going in and making the payment.
How much does she have due on this?
The evening at 10:36, it's 380.
She owes 380. Okay, I'm sorry. I thought that was 180. And lady, here's what I'm gonna do. I'm proud of you that you graduated or about to. Where'd she go? She dropped. I'll pass these. Miss Green Gifford, you there?
Yes, I'm so sorry. My laptop died.
It's okay. It's Ohio internet. I get it.
Mm-hmm.
All right. So the 1781 case I adjourned out to August 12th, 9
Okay.
a.m. On your other case, I'll say to you, congratulations. I'm proud of you for graduating.
Thank you
owe
so much.
You owe 380 on that. I'm gonna waive 255 of that just for a graduation present. All right. You go
I
up there and do.
appreciate you. I'm always on Facebook saying how you my favorite judge. So thank you. Say, don't talk bad about that man.
I appreciate it.
Mhm.
That'll leave you a balance of $125 on that case.
Okay.
And so I'll just say pay that by August 12th. So pay that by that date, and then we can get rid of that and we can figure out where we're there. Fair enough?
It sounds fair to me. Thank you so much. I appreciate you.
Not a problem. And again, congratulations to you.
Thank you. I'm gonna keep on talking good about you. Don't worry.
Okay. All right. Well,
Y'all
I
have a
appreciate
good one.
that. Yeah. All right. Take care.
This is the other one. We can do it today. Are you Gina Michelle Hazer? Yes, I am. We've met, but I need to identify. Yes, this is time. You got charged with trespass, and you've been trespassed there before. They allege that on April 20th, that you were at the Iceberg Penguin plant at 8 o'clock at night. The ticket says Gina has already been trespassed and cited for being on this property within the past couple of months. Located her drunk and yelling on the property at 8 o'clock that night. You've got several other of these that you've been convicted of. You have an attorney-free trial set for June 19th on another trespass charge. How do you plead to this one? Not guilty. All right. Who's your attorney on the other case? It's supposed to be Bush. It says there's another paperwork. It says Timothy. Have you called him? I don't have a phone, and I'm drowning. How about if I just put you in jail from now till June 19th, and then your lawyer will be able to get a hold of you to discuss this? You got a disturbing the peace from 24. The fine was big, $475. You have another trespass from 2025, which is $150, which I know I still owe you guys money. And then you have this new trespass that's set for pretrial with Attorney Bush, 26454 OM. Would you haven't even bothered to call your lawyer to discuss the case with him? So I know that you're struggling. You're essentially homeless. My mom's missing. Do you have a place to live now? I'm safe, away from a lot of people. Where are you? Outside. No way. How'd you get here today? A friend. All right. Well, you live in Sturgis. Mr. Bush's office is on Main Street in Sturgis, and it's been there for 80 years. It couldn't be any more easy for you to contact your lawyer. But I'm going to show that you plead not guilty. When you're outside, now it's getting warmer, but you're not safe. You're subject to all kinds of threat. And I've talked to lots of ladies like you who are struggling with homelessness, and they're very often victimized. You can't keep doing this. The drunk part is in there also.
I'm gonna appoint John Bush.
Can you make it part of her bond that she not be back on the Penguin property?
Yes. Set attorney pretrial for June 19th.
Actually, Penguin saved me like indubitably. They saved me last year.
Say that again?
Penguin saved me last year.
By staying on their property?
No, they were out there doing their maintenance for the cargo, the box cars that they have that has the plastic comes through it. Aaron McDaniel was he broke my leg and was going to drag me back down the tracks, and they saved me like no other. And they talked to me fluently.
So
Like,
where's your camp? Is it back there behind?
No, I removed myself.
Well, you stay away from Penguin property until.
Indubitably.
All right.
But they did me a really good solid on that note, and I do talk to them fluently.
Are you connected with Pivotal or any mental health services?
If I could only get that far.
Do you have any source of income? Did you get Social Security, disability, or anything?
For some weird reason, from that day that I lost 80% of my heart at the jail in 2021.
Yeah, you've also got some significant health issues. Seems
Yeah, well, I didn't
once
have
had to wait
those
for you to get out
before,
of the hospital.
but they denied me 3 times, which is crazy because there's like 5 bullets that you can't be denied for, less than 20% of your heart, and illness that leads in death.
Well, you're not doing well. You're out on the street. You have no money. You got an alcohol problem.
Yeah,
me too. And you're just trying to make your way in the world. Do you need a bus pass to get back to Sturgis? How'd you get here?
A friend.
So you have somebody to take you back? All right.
Today.
Now, you got 2 cases that you owe money on, but you don't have any money. You don't have enough money to eat.
Sorry about that.
And you have 2 cases pending. The previous trespass, 26484, and now this one. And both of them are going to be set for Friday morning, June 19th. That'll be in front of Judge Pattison. Maybe he can figure out what to do with this.
Right.
You're to stay off the Penguin property.
Mm-hmm.
If anybody was old enough and they were from Fort Wayne, they would know what Penguin Point was, but this is not that. Penguin Point was a regional fast food place.
I don't,
All right, you go in the court officer. We're going to appoint Mr. Bush. The clerks are going to give you a notice. I want you to be here on June 19th. Excuse me.
Right?
Yeah, June 19th is the date.
Okay.
Or a bench warrant will issue for your arrest. All right, you're good to go. Good morning, sir.
Good morning, Your Honor.
Are you Bradley Warnke?
I am.
How do you say your name?
Bradley Warnke.
All right, that was close. Hello, Abby. You got arrested last night or the night before and charged with a number of things here in St. Joseph County. Also present with me, you may be able to see her on the screen, is Jeanette Jackson from the Public Defender's Office. They allege that here in the village of Centerville on May 11th, that you did maliciously destroy a building at 46 Jane Street that belonged to Abigail Hosteller. And the injury was $200 or more, but less than $1,000. So that's charged as a misdemeanor, punishable by up to a year in jail and a fine of up to $2,000. Count 2, malicious destruction of property of motor vehicle tires belonging to Abigail Renee Hosteller. Again, more than $200, but less than $1,000. That's also a misdemeanor, punishable by up to a year in jail and a fine of up to $1,000. Count 3, malicious destruction of a motorcycle that belonged to Malachi Cady.
Again, over 200 but less than 1,000, that's also a misdemeanor, punishable by up to a year in jail and a fine of up to $2,000. They also allege that you stole his license plate off his motorcycle, which they found in your truck in Kalamazoo. That is charged as a misdemeanor larceny less than $200, and it is punishable by up to 93 days in jail and a fine of up to $500. I'm sure it would be Ms. Jackson, the public defender's recommendation that you plead not guilty, that I appoint an attorney to assist you with this. Is that agreeable with you? Is that agreeable? You plead not guilty and I appoint a lawyer to help you?
That's correct.
I'm gonna set an attorney pretrial for 6/5/26 at 8:30 here at the courthouse in Centerville. Now, you know where Centerville is. Apparently you were dating this woman who lives in town. They arrested you at your home on the 11th of May.
Yes, Your Honor.
How long have you been in jail?
This is I believe my third day.
Yeah, the 11th at night. Yesterday was the 12th. I don't know why I didn't see you yesterday. Apparently the paperwork, the charging document wasn't completed, but obviously I need to get you arraigned. Are you employed?
I don't know. I've been here for 3 days, so I hope I still am. And I've got 2 small children I'm ready to go see at home.
Where did you work?
I work at National Door Systems.
Where is that?
It's in Pontiac, Michigan, but I just cover the west side of the state for them. So we cover the whole state. I don't go to Pontiac every day.
All right, so you're a contractor that installs doors?
Essentially, yeah, I'm a door technician that fixes doors, yes, when they break.
Garage doors or just doors?
Like automatic doors, like sliding doors, swinging doors, like Meyer and hospitals and stuff.
Do you stay in Michigan or do you also go to Indiana?
I maybe go to Indiana, but it's very rare, like Mishawaka, maybe like Meyer or something along those lines. But yeah, not really. Maybe Toledo sometimes, but not a lot.
Reading this is embarrassing. You're down here allegedly slicing her tires, damaging the motorcycle, damaging the building. They go to your house, they find blood on your truck, they find the stolen license plate in your truck, and they arrested you. Prosecutor charged it only as misdemeanors. There is a domestic violence that might be out there somewhere. I'm going to set bond in this amount because of the nature of the matter. You came from somewhere else to here, did several items of damage, threatening people. It's a domestic relations circumstance. I'm going to set bond at $1,000 cash or surety. It is a condition of your bond that you appear for any examination, arraignment, trial, or sentencing. You abide by any judgment entered in this case. If you do become convicted, you may not leave the state of Michigan, except you may go to Indiana or Ohio for work. You're not to commit any crime while you're being released. You're to provide an email and telephone number upon release and notify the court in writing of any change of address. You're to not use drugs or alcohol. I suspect there may have been some underlying issue there. Do not possess or purchase a firearm or other dangerous weapon. Do not harass, beat, molest, wound, stalk, threaten, or engage in other conduct that would place other people in reasonable fear. That includes Abigail Hostetler and Malachi Cayley. And you shall not assault, harass, beat, intimidate, or threaten either of those people. You're not to have any contact with them. And you're not to go to James Street, Centerville. Do you think you'll be able to post that bond?
So I need $1,000 cash to get out.
No, you need $100 to post with a surety company or $1,000 cash.
If I could use an ATM and maybe transfer some money on my phone, yes, I could get it.
All right, well, they'll deal with you with those circumstances at the jail. Now, your next court date is Friday, June 5th at 8:30 here at the historic court building in Centerville. I don't want you to have any contact with Ms. Hostetler or Mr. Cayley. You've got a sharp instrument that allegedly punctured all of her tires. 4 flat tires worth more than $200. The prosecutor charges this as a misdemeanor. I don't know what the damage was to the motorcycle or the building. And they apparently recovered his license plate from your truck. I don't know if they've returned it to him or not. At any rate, the bond is $1,000 cash or surety. They will send you this bond form to sign. All right, Mr. Warnke, stay away from these people. You're going to get some paperwork with the attorney's name and number on it. I want you to call them, make an appointment to discuss this with them prior to June 5th. So would you take that out to Shana and she can process that. All right, sir. Hopefully you'll be able to get out of jail. If not, you're going to sit till June 5th. Sometimes there's a consequence. But I was reluctant to do a PR bond because of the threatening aspect to this. All right, you're good to go. All right. Sir, could you remove your head or remove your hat, please? You're Stephen Bird?
Yeah.
Mr. Bird, the allegation here is a criminal matter, and if you enter a plea, you and both Mrs. Lopez have rights called your trial rights. And if you do enter a plea, you give those up. Those include the right to be represented by an attorney. The public defender is here to make sure we're doing everything right, which is not actually representing you. But if you ask me to appoint an attorney, I could do that. If you had a trial, you'd have the right to take the witness stand and testify on your own behalf. You don't have to, because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent, unless the state was able to prove your guilt beyond a reasonable doubt. You understand? You have to speak your answer.
Yes.
All right. Were you driving a car in Sturgis on March 21st?
Yes.
And did you not have a valid license?
I did not.
All right. What's your circumstance? Are you able to get a license?
Yes, I had to take some points off my record to get that driver's license.
You're pretty young. The younger the kids are, the more likely they are to have valid. Were you born here in Sturgis?
Yeah.
All right. So there's no issue regarding residency status or anything. You just need to get your license. Again, yeah. All right. This is going to go on your record and might prevent you from getting your license for up to 180 days. Do you understand?
I understand.
How'd you get here?
My brother dropped me off
Where's he?
in the parking lot outside.
Defendant paid speeding ticket. What do you do, Mr. Lopez?
I
You
just
work
work.
somewhere?
I just work, Your Honor.
Where do you work?
Morgan Olson.
Very good. Are you missing work right now?
Yes, I took the day off.
Well, stop driving around with no driver's license. It might make things easier. $100 fine, $75 crime victims rates fee, $50 state minimum. All right, can you pay that today or need time to pay?
Yeah, I can pay it today.
All right, the courthouse will take you out there. You have $225. This will put 2 points on your driving record. And don't drive till you get your license. It's too expensive. Eventually I'll put you in jail if you keep doing it. But you're good to go. Stephen Boyd. Good morning, sir. Are you Stephen Boyd?
Yeah, I'm Stephen Bird. Yeah.
Bird, I'm sorry. Stephen Bird Jr. File number is 26940. The prosecutor has agreed to dismiss driving suspended first offense, and you're going to plead guilty to impeding traffic and no valid operator's license. Is that correct?
Yes, that's correct.
All right, impeding traffic is a civil infraction. It carries a $100 fine, doesn't carry any points. And you were ticketed for that. No operator's license is the same as the last guy. It's punishable by up to 90 days in jail and a fine of up to $100 plus costs. Do you understand the charge?
Yes, I do.
And you're going to plead to that charge?
Yes.
Anybody threaten you to get you to do that?
No.
I promise you anything?
No.
We've got so much stuff in here. We've got several days crammed together, and according to this was at Chicago Road and Prospect Street in Sturgis. Eastbound at 46 and the 35. Turn right on red were not permitted. You spend it out of Indiana. So were you driving in Sturgis on that day?
Yeah, yes, I was.
Where were you going?
I was going back home.
To where?
Do you want my address? That was 300 North Nato Street.
All right. Now, when I talked to you last time, you were working 2 jobs. You were going to bring proof of your license. And apparently you didn't. Well, do you have a license now?
Oh, no, I didn't get the insurance yet because my check got delayed. And I'm still kind of behind on bills, but it should come later this month. So next month I should get the insurance.
All right. The fine on impeding traffic is $100. And that is due June 15th. The driving suspended charge is dismissed. Pleaded no valid operator's license and impede traffic. When I talked to you on April 8th about what you were doing, I set the pretrial for this morning to see if you were going to get your license or insurance. And you drove to court and then you lied to me about it. I said, did you drive here today? And you said no. And I watched the video and you drove in and out of the parking lot. How'd you get here today?
I drove here today.
All right. Well, you can't drive.
I have nobody to take me.
You've also got
if I don't drive here,
$20 of unpaid fine and costs. All right, I'm going to make the fine as low as I can make it, $125. I'm ordering 2 days jail, one for the day you drove to court and lied to me about it, and one for today. You're going to jail right now. Your car's in the parking lot, and you better call somebody to come get it.
Okay.
Gotta pay $125 and 2 additional days in jail. I'm disappointed about this, but I appreciate you. You lied to me the first time. At least today you told me the truth. But that ain't the way to do it. You keep driving. You don't have a license. It's suspended. You got $520 worth of unpaid fines and costs. You're driving around with no insurance. It's all bad. So you're going to jail for 2 days. You owe $125 or 2 additional days. You go with a court officer. They'll let you call somebody. Get my cases straight. The probation violation arraignment. Ms. Tepper was here in a timely manner. Let's talk to Tricia Marie Tepper. Please come up and have a seat. I'm not sure what I'm doing here, but this on base is just all crammed together. 4 days worth. Everything. I think it may be the way my filter is set up. 88 files in here. It should be divided out. This is People versus Tricia Tepper. The file number is 2522085SL. Ms. Tepper was convicted of domestic violence, second offense, and placed on probation. Her probation agent, Priscilla Walton, is here and has filed a probation violation petition in this case. One of it's in order. Allegation, Ms. Tepper, you were placed on probation in December 29th for 12 months. The allegation filed by your probation agent is that you failed to abstain from the use of alcohol or drugs or test as demand. So the matter was set for a probation violation arraignment today. Allegation is that you continue to test positive for methamphetamine and marijuana. Ms. Tepper is in violation of Article 10. The status report states, since she started alcohol and drug testing on 1/12/26, has been testing positive. She was positive on 1/12, 1/16, 1/19, 1/22 for THC, methamphetamine, and amphetamine. On 1/28 and 1/30, she tested positive for THC. On 2/3 and 2/6, positive for THC, methamphetamine, and amphetamine. On 2/11, she tested positive for THC, methamphetamine, amphetamine, and alcohol. On 2/10, the probation officer received a call from the defendant saying she was going to admit herself to Enlightened Recovery in Kalamazoo, admitted to a 28-day inpatient program, which is why we didn't do a bench warrant at that point.
Yeah.
She continued to test positive after her treatment program. She was positive on 3/16 for methamphetamine and marijuana. 3/20, she was diluted. 3/23, 3/26, positive for methamphetamine. No show for testing on March 31st and a refusal on 4/24. She was given an oral fluid test and she had stuff in your mouth.
Hey, what?
And on 4/3, you're positive for methamphetamine, amphetamine, again positive on April 6th. So we're not accomplishing very much. You're continuing to test positive, almost every test. Priscilla came to see me and said, what do we do here? And I said, well, let's file up a probation violation. So that's the allegation. Her recommendation is that I revoke your probation and give the 10 days of jail that was
Left.
suspended and discharge you from probation. We're not being very successful. So that's the allegation. You have a right to have a hearing on that allegation where it must be established beyond at least a preponderance that you did violate the terms of your probation. Your original lawyer was Mr. Timothy George. And if you wish to have a hearing on this allegation, I could appoint Mr. George and set it for a hearing regarding these allegations. Or you can simply enter a plea today, knowing that I'm going to revoke your probation and give you 10 days in jail. Would you like to have a hearing on this with assistance from a lawyer?
I would.
Right now, this ain't working. There's no sense to have you on probation to keep you off drugs if you just keep testing positive all the time. You did do a 28-day program and immediately relapsed. Now, 10 days is the recommendation. What's actually available is the balance of 1 year.
Right.
Are you still living on Cowles Road?
I am currently staying with Wayne Ball in Sturgis or my father's house. It's the Broke or Sturgis resident. The 1010 Green Lawn, sir.
What's the address?
1010 Green Lawn in Sturgis.
Are you Wayne Fall?
Yeah, that's Wayne Ball.
Okay. Well, it's good to have some support.
Yeah, my son was, I'm sorry, can I speak? My son was originally going to be here with me and he's in the hospital right now. So I was hoping to be able to be there for him.
Point Tim George and set a PV hearing. You're going out every day and getting methamphetamine. I don't know how you're paying for it. I don't know who's selling it to you. There's a special ring in hell for those people. Now, today's May 11th. The last time we actually had a test that was positive was April 3rd at 6. If I tested you today, what would it show?
It would be positive for meth. The stuff's been having amphetamines like fentanyl in it because I tested positive for fentanyl as well. So they've been lacing it with fentanyl. I don't know if the meth will be in my system because it's been a few days since I did the meth. I do have a medical marijuana card now, Your Honor, for my severe pain and stuff. So the marijuana was something I should have handled and got taken up with you.
You have a medical card perhaps, but I didn't approve.
I'm not supposed to
You're
do
gonna
that.
kill yourself. You're buying methamphetamine off the street. It's laced with fentanyl. And I'm not telling you don't know. But this probation doesn't have any purpose.
Right.
All right. Now, the recommendation is 10 days. Bear in mind, I don't know how many days you serve, but DV second is punishable by up to a year in jail. We'd certainly get you clean if we gave you about 300 days in jail.
Absolutely.
But the jail doesn't really want me to give you 300 days and take a women's jail bed. But right now, this has got no point. But in light of that, you still have your rights, and the right is you have a right to have an attorney and have a hearing on the matter. So we're going to take her out to the counter. We might as well not even test her anymore. There's no point. It's expensive. She indicated she'd be positive today.
Mm-hmm. May I speak with you, sir, real quick?
Yes.
I was curious on so this whole case, I haven't really been able to speak up because I get like really scared in front of police or authority. And since I've been with Randy, been married to him for 10 years now, I didn't realize a narcissist person would totally take effect on myself, what it has. But I am not a violent or angry person. I've been dealing with the meth, obviously, but he's got psychosis and deals with his brain.
I took your plea, and you and Randy have certainly had your issues over the last 10 years. He's been convicted of assaulting you, but is trying to deal with your drug addiction.
I know.
With zero success.
And I could be off of it. I didn't have any problems, and then he guilted me into coming back there and talking to him.
I know, that's all ancient history. That was last December. It's now.
No, I'm talking about like when I got out of rehab.
Oh, you went back there after you got out of rehab?
I'm sorry?
You went back to Randy's after you got out of rehab?
Correct. Randy had a social, not there to stay, but we were supposed to get work on. We're gonna get our counseling where we're supposed to, la la la. Well, I got there. He's supposed to come to the rehab and pick me up at 10 o'clock in the morning. We had a family session with my counselor, Peyton, at the Enlightened, and everything was fine. As far as Randy was staying clean.
Well, all right. I don't want you to tell me too much more about this until you have an
Okay.
attorney here
That's
to
fine.
assist you. But
I just never been able to stick up for myself because I've been so scared and I freeze up and then I can't even think. It's retarded.
well, you don't have much of a support system. Is there a condition of probation she wasn't have to contact with Randy?
At one point it was. And then it's, I can't spend the night.
I believe that they did, Your Honor.
That's very unhealthy.
Let me see.
Well, at some point in the near future, I'm gonna get off your back. And I feel you're going over the waterfall and I'm just standing on the shore watching you go over the edge. But I'm paddling the one way and you're paddling the other. And
I'm paddling both ways. It's retarded. I don't mean to keep saying that word, but it's just, I don't want you to think that I'm an angry and violent person that shouldn't be out there because it's not true.
Your Honor, she, the original judgment was just to not reside at the Vicky Drive address.
all right, this will be done sooner than later, probably before the end of May. There's a likelihood that there is jail in your future. You go with a court officer. We'll get a hearing date.
You say you go with him?
Paul, would you take this
Yes.
one too?
Give me a call this afternoon as well. Okay.
Do you need to see her while she's here?
I just need to update the address because the address I have wasn't broke.
All
We
right.
I can stay.
Okay.
Yeah, why don't you see her first? I had a breakdown sheet of how much Mr. Fox owes. I don't have it with me now, but let's start with Brittany Pond. In fact, why don't you both come up here and have a seat at the defense table? Are you Brittany Dawn Pond?
Yes.
Now, the public defender isn't here, and that's a bit of an issue, but we'll proceed. This is file 26714OM. Ms. Pond, you're charged with trespass under Sturgis City Ordinance. Trespass is a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $500. Mr. John Elmer Fox Jr. is also present. He has filed 26677OM and 26713OM, both alleged trespassing April 13th and April 14th. The city of Sturgis is dealing with their homeless issue by giving everybody trespass tickets. Some of the factories and other commercial businesses are complaining about homeless people on their property. Mr. Timothy Reed, the Sturgis City Attorney, was here this morning and you weren't. So I'm gonna set these for pre-trials with the city attorney. Ms. Pond, do you have an address?
I do not.
Well, the good news is I'm going to recall the bench warrant. I'm going to set a pretrial conference with the city attorney. I think I set him for the 19th. That can't be right. I'm going to set him for the 26th. Mr. Fox, you got 2 of these. You've also got several $100s worth of other unpaid fines and costs, which I don't have in front of me right now. Once again, the public defender is not here, and neither is the city attorney. They were both here this morning. Do you have an address?
This is mailing address,
Where are you guys camping, or where are you?
Grace Point,
On the property or in the church?
at the church.
Well, simply citing people with a ticket and a fine that they don't pay isn't a very helpful solution. I don't know how you got in this state. I do know you deserve to treat yourself better. I'm going to show you plead not guilty. I'm going to recall the bench warrants. Set a pretrial with the city attorney. Miss Poland, I think, is floating around out there too. She shows up, I'm gonna do the same thing with her. May 26th.
She's actually at home sicker than I'll get out.
She's at where?
At the spot, at her spot, sicker than I'll get out. Like she couldn't even get up and get the phone.
You guys need bus passes?
Possibility.
How'd you get here?
A friend of ours brought us.
All right,
We were on the truck problems.
Just to get back here on the next date. I got some very generous people that watch my YouTube channel who have donated bus passes. All right. These will get you here. If you show up and you need them, I'll give you 2 more to get you back. But I want you to go out to the counter. I'm having the clerk give you notices because I got other stuff to do. And I want them to tell you how much your unpaid fines and costs are.
She already did that.
She did it already?
Yeah, some of them.
All right, you go out in the court office.
Thank you.
Okay, and we are on the record in the matter of the city of Wyandotte versus David Rodriguez, 26278.
Ready, Your Honor. Morning, I'm the old boy here on behalf of David Rodriguez. Mr. Rodriguez, please state your name, sir. David Rodriguez. Thank you.
All right. And have you been here recently, sir? Weren't you? Have you been here recently, sir?
I've been here before.
That's what I thought. Your attorney's cringing, but in any event. Weren't you just here in December?
My head, I'll keep tabs.
Well, okay. Kelly, what happened with this matter? The December 11th, 2025 matter. Please.
December 11th is in warrant status.
Oh, great. We're going to pull. Was it in warrant status because he didn't appear for his arraignment pretrial, or does he go or show? Great. We're going to pull that case because going to guess that has something to do similar with this charge as well. What also happened with the matter from April of 24, Allie? April 7th.
Those are the ones that I see under his name.
I'm showing them from April 7th of 24.
Okay, because his name is spelled incorrectly. But that one's closed out. It's then that took a guilty plea.
To
Public intent. And alcohol tether first situation. Bail term 21 days, credit for transfer 14 days. Alcohol tether first 60 days.
Okay, thank you. All right. And I believe that's as a result, that's after the matter from January 8th of 24 for public intoxication, whereby you pled guilty and I heard fines and costs. And then you're right back here in April. And now you're back here again and you've failed to appear in December. So we're going to pull that case as well and handle that, counsel. So that way we can have that all.
That one's closed out.
The one from December?
That one. Oh, I'm sorry. The one from 2024. The one.
That one's closed out. The one from December of 25, you said has a warrant, right? Okay. And then we'll recall these matters.
Thank you.
Thank you. All right. Let's go off the record. The Parsons check-in?
Who?
Parsons? Oh, I'm asking. Oh, okay. Oh yeah, that's the list here.
Oh, thank you, Your Honor.
You're welcome. Quinn, Bristol Quinn check-in? Miners, Wayne County Jail. Charles Thomas, Wayne County.
No.
No. Okay. We're on the record, the matter of the city of Wyandotte versus David Rodriguez, 26278, and also 251698.
Ready, Your Honor. Attorney Neil Boy here on behalf of David Rodriguez. Mr. Rodriguez, state your name again, please. David Rodriguez. Thank you.
Okay. And so the court will note that Mr. Rodriguez was arrested on the new case March 3rd, but he bonded out through the police department. But there was also this warrant, so I don't know, maybe there was just an overlap, and it may have, not been entered in the system before you were released, because if the warrant was there, they may not have released you. But let me say one thing, sir.
Yes.
I'm aware of the, incident that occurred here regarding your phone. There may be places where disrespect of courts, court staff, or otherwise may be tolerated, but it's not tolerated in my court. Do not speak to my staff in the manner in which you did. Am I clear on that?
Yes, that was a mistake of mine. It's a phone. I cleared it up as.
Your comment to my court officer is unwarranted.
Well, I was in here all day without my phone going off. He should have probably maybe understood, you know.
Sir?
Yeah, I did leave though.
Sir?
I did.
Stop, please.
Okay.
Nothing that you're saying justifies or excuses your comment to my court officer. Counsel, as to the new matter, as to the warrant, as to the arraignment.
Client waives formal reading, stands meeting to that charge.
The court will recall the warrant, waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and then ask to the pretrial counsel in this matter as well.
My client plead guilty to that charge, is that correct? Yes.
Okay. Sir, please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. And you heard the plea that was placed on the record as to both matters, correct?
Yes, I have.
And as to the new case, the amended charge of disorderly conduct, how do you plead?
Guilty.
As to the older case, the charge of disorderly conduct, how do you plead?
Guilty.
And you've gone over your advice of rights with your attorney as to both matters, correct?
Yes, I have.
And you understand all of those rights.
Yes, I do.
You also understand, sir, by entering into a plea that you'll be waiving some of those rights.
Yes.
You understand the possible penalty as a result of your plea, whether in this court, any other court or administrative agency.
Yes.
Knowing all of that, do you want to continue with your plea?
Yes, I do.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
Any immigration issues? Counsel, if you can please order your client.
Yes, Mr. Rodriguez, do you recall being in the city of Wyandotte on about March 3rd of this year?
Yes.
And then, yes, and you are familiar with the Camino Real Mexican Grill in the city of Wyandotte, correct?
Yes.
And on that date and time, you had an altercation or an incident there. Do you recall that?
Somewhat.
Okay, you were drinking that day and you were had an altercation with folks in the parking lot. You were acting in a disorderly fashion. Is that correct?
Maybe according to their opinion, but I got the okay to go behind there with the owner of the store.
Mr. Rodriguez, telling the court that you had permission to urinate in public.
No, I do not recall that. I had to go. I just remember I had to go.
Okay, you agree with
I didn't have time to find a bathroom, I guess.
You would agree with me that that's disorderly?
Yes, it has to be.
Would you recall also being in the city of Wyandotte on or about 11th of December last winter? Do you recall?
Somewhat.
And at that time you were at the Dollar General, do you recall that?
Yes.
And you were purchasing and drinking and consuming alcohol in the Dollar General at that time, correct?
Inside the store? No,
You were in the vestibule, beside the doors.
I would just have to say so.
Well, no, you can't, okay? Either you did or you didn't. You know what?
I really do not recall.
All being arrested that day.
Yeah, I remember the officer.
Okay, what did he arrest you for?
He drove me home.
He said, all right, why did he do that? What was going on?
Because I was upset that day and I guess it showed up on, and while I was inside the store, it had nothing to do with them. And
Okay.
They just didn't understand me.
Were you drinking in that store?
No.
All right, Your Honor, we don't have the plea. How would you describe your conduct in that store that day?
Well, after going through what I went through, I guess you could classify it as disorderly.
What did you do?
I got upset.
Okay.
About something that happened previously. I went to the store to, and it was still festering up in me. And what happened, I put in my debit card into to purchase my merchandise, and it was going off, and I was already upset, so I think I hit my hand on top of the counter, but it wasn't really that bad, but it was enough to set people there almost like, out of hand, I suppose,
Okay.
I was just angry.
You would agree with me that that's disorderly conduct in a public business?
I would have to agree. I would rather not fight it.
Right, I'm satisfied with that.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the charges. Dismiss the original public intoxication charge on 26278 per the plea agreement. And you asking for immediate sentencing?
Mr. Rodriguez, you want to resolve this today with regard to sentencing?
Yes, if I may, I do get some Social Security, and I'm able to pay so much money per month, starting the first of the next month.
Okay, and I appreciate that, sir, but quite frankly, the court's not as concerned with the fines and costs as it is with you staying sober.
Oh, yes.
Right. So when's the last time you consumed any alcohol?
So long ago, I couldn't tell you. I was had to say months,
A month?
Yeah, from my last incident.
All right, counsel, what else would you like the court to know?
Your Honor, obviously, Mr. Rodriguez says you have a problem with alcohol per se. That might be a benefit to the society in general. Is what we'd ask the court to move towards.
Yes, the court's going to do 90 days on the alcohol tether on 251698, as well as 26278.
Word hasn't been 90 days.
Sure do. It's going to help you stay sober, sir.
Well, I just stay inside the house and don't go outside.
So you don't have a GPS tether. You can walk around wherever you want to walk around. That you're legally permitted to be with, to be.
Can I walk around with that tether on?
Of course you can. All right, as the 251698, the court's going to order a $100 fine, $200 cost, crime victim assessment fee of $75, justice system assessment fee of $50, for a total of $425. Is there a warrant fee on that one, Ally?
$50.
$50 warrant fee.
If I'm major on it, can I pay like $50 down, like Social Security? Maybe it's like $50 a month,
Okay, hold on, just one moment. And then on the 26278, the court's going to waive the fines and costs. So yes, you can pay $50 per month, sir. What day of the month works best?
Third,
Third?
yeah.
All right.
That's
so
the day I
beginning
get my Social Security.
Okay, we'll begin June 3rd. All right. Go over to probation, sir, so you can get information about having that tether. Okay, good luck to you.
Probation.
All right, we're on the record in the matter of the city of Wyandotte versus Anthony Vega, 26505.
Good morning, Richard E. Toronto, PC38. We had to my client is approaching. State next up, state your name, sir. Anthony Vega.
All right, good morning, and please remove your hands from your pocket, sir. All right. I know we have a band of brothers today.
Yes.
All right, and so counsel, today's the date scheduled for pretrial in this matter.
Yes, Your Honor. The court may recall that I did, in fact, arraign all three of the co-defendant brothers And they all equally said that they had no objection at that time to those arraignments. And now I've ended up with Mr. Anthony Vega only as his appointed counsel. And you have no objection to that. Is that correct, sir? Yes, sir. All right. And Your Honor, may I proceed with the resolution?
You may.
Your Honor, after retrying the matter and with the prosecutor and my client was to avail himself of the offer, he will plead guilty to the amended charge of disorderly conduct. I've explained to them what that entails. He understands the charges, all maximum penalties involved, and also the signed and advice of rights partner. In fact, understanding waiving those rights by entering into this plea freely and voluntarily. He will plead guilty to the amended charge of disorderly conduct pursuant to HIDA, Homes with Trainee Act. I told him what that entails. I believe he qualifies, and we're ready for the court's examination.
All right, sir, if you can please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, nothing but the truth? Okay, sir, in the Wayne County Jail, you can keep yours down. I'm not addressing you right now. So thank you very much for paying attention, though. And sir, you did hear the plea that was placed on the record, correct?
Yeah, okay.
As to the amended charge of disorderly conduct, how do you plead?
Guilty, Your Honor.
You've gone over your advice of rights with your attorney, correct?
Yes, ma'am.
And you understand all of those rights.
Yes, ma'am.
You also understand the possible, that by entering into a plea, you'll be waiving some of those rights.
Yes, ma'am.
You understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency. You also understand what the HIDA status is, correct?
Yes, ma'am.
Knowing all of that, do you want to continue with your plea?
Yes, sir.
Anybody promise you anything, threaten you, or coerce you in any way for you to enter into a plea? All right, thank you. And counsel, if you can please vote to your client.
Yes, thank you. Mr. Vega, on about April 18th, 2026, how old were you on that date and time? And you were out with your brothers, correct? Yes, sir. There came a time where you tried to get back to your apartment, but the police had told you to stop for some reasons, correct? And so you continued to go into the apartment disregarding their commands. Is that correct? That's correct. And while in there, they became kind of disruptive amongst the good peace and order of the neighborhood, correct? Got a little loud, police were shouting, you groups were talking back and the like. Is that correct, sir? And I'm satisfied, Your Honor, with the disorderliness.
All right. The court is also satisfied the plea is knowing, voluntary, factually accurate. The court will accept your plea to the amended charge, dismiss the original charge per the plea agreement, and determine your eligibility under HIDA at sentencing. Sir, have you relocated with your brother?
Yes, ma'am.
Okay. So did you continue that new address?
I did not. His address in Waterford, Your Honor.
Okay, so he will have to make sure he's changing his address with probation.
All right.
If you're to test right now, sir, what's in your system?
We.
Okay, when's the last time you used it, sir?
Today.
Today. Okay, sir. I don't believe, if I recall, that you have a prescription for marijuana. No. So then tell me, sir, why are you violating this court's order and using marijuana just because you feel like it? Just before you answer, I don't know is not an acceptable answer in this court.
Were you nervous about coming to court, sir? You thought that might help? Yes, sir. You're not still under the effects of marijuana, are you? No, sir.
Well, when did you use it, sir?
I would. 8
a.m.
Mm-hmm.
And so you're not currently under the effects of marijuana. Tell me how that works. You only used it 2.5 hours ago, and you're still not under the effects of marijuana.
Just for the record, Your Honor, I had no problem communicating with them.
I understand. But just as though we have to make sure somebody's not still legally intoxicated, I need to make sure that this individual that doesn't want to follow the court's orders is not currently under the influence of a substance, which I would think, I mean, I don't know. I'm not a marijuana user, so I don't know how those effects work. But I would think that if you used it 2.5 hours ago, sir, you would still be under the influence of that. Correct?
Yes, Your Honor.
And if you weren't, then it would seem as though the marijuana's effect was not useful to calm your nerves about coming to court today. Would that also be correct? So it can't be both. Which is it, sir?
He'll call me.
Right. So you're either
Yeah.
currently under the influence and you're calm, or you're not currently under the influence, and then the use of the marijuana was for nothing because now you're in front of the court here and now you're presumably not calm. So which is it?
I'm calm. I'm intoxicated.
Where does one get marijuana at 18, sir?
I bought it.
You bought it.
Where I buy it from.
So you do know, in addition to violating this court's order, sir, you're putting yourself at risk because you have no idea what that marijuana is laced with. Do you understand that?
Yes, ma'am.
And yet you choose to use it anyway.
Yes, ma'am.
Great. Okay. Well, so counsel, I can't accept the plea today because your client's under the influence, and I don't know that he's making this plea knowing, voluntary, or not.
I agree.
So, sir, you're gonna have to come back another day.
Hopefully the plea will still be on the table at that time, Your Honor. And I caution my client not to be under the influence of anything when you come to court, correct? Next time?
Yeah.
Sir, you're 18 and you're not making great choices.
I'm working on it. I got my permit, I'm getting my license, and then I have a job I can pay for me. I'll be.
That's great. You do realize, sir, if you use marijuana and then you drive,
Yes, ma'am.
that's illegal also. Even if you used it 2 weeks ago and it still shows up in your system, that could be a problem for you. Sir, I'm not going to do a bond violation hearing for you. However, I am going to order you to participate in random testing. Because when I say something as an order of this court, sir, that's meant to be followed.
Yes, ma'am.
So we're going to test today, so we have a baseline level. All right, Allie, when are we having Mr. Vega come back?
June 10th at 9:50.
June 10th at 9:15 a.m. Bond and conditions are continued.
Thank you, Your Honor.
Stop at probation, sir. You're going to get set up with your testing information.
Thank you.
You're welcome. All right, so let's go on the record in the matter of the City of Wyandotte versus Richard Vega, 26504 A and B. And counsel?
Morning, Your Honor. Your Honor, for the record, John Goldfarb, 758 on behalf of Mr. Vega, please put your name on the record. John Vega Jr.
All right, and so good morning. Today is the date scheduled in this matter for a pretrial, the third of the brothers today. And counsel, as to the pretrial.
Well, Your Honor, first, I believe it's also.
No, he's been arraigned.
Pretrial. I apologize.
April 20th. All three were in custody.
I'm sorry, Your Honor. Thank you. Your Honor, as for the pretrial, I've had an opportunity to speak with Mr. Vega as well as with the prosecuting attorney. I've also had an opportunity to review the police reports, etc. It's my understanding that in return for a plea to disorderly conduct to be taken under HIDA, the charge of resisting and obstructing would be dismissed. As to the no insurance, which is not under HIDA, as well as the he would plead responsible to no proof of insurance. And as to the no operators on possession, he would he would be pleading guilty to allowing an unlicensed driver to drive.
Okay.
That will not be under HIDA as well.
Well, I don't know that this current one will be under HIDA, given your client's criminal history.
Your Honor, he is 22 years old, and HIDA is eligible.
Right, but it's court discretion as to how often it can be used. I don't have to accept it.
Your Honor, my understanding is that HIDA, when with even a prior, so long as within the, I'm sorry, I'm trying to think of the right word. As long as it's within the particular age group, I'm not saying under 20, but with the agreement with the prosecuting attorney, is the prosecuting attorney who has to at least allow a plea to be taken.
I understand that, but the court has discretion as to whether or not it's going to accept the plea with a HIDA designation, or whether I'm going to find that your client's eligible under HIDA. And I have to tell you, counsel, absent something that tells me that I have to find your client eligible under HIDA, given his criminal history, specifically a felony fleeing and elude police officer, 4th degree, that your client pled guilty to in 2021, and now given these charges, I'm not likely to find your client eligible under HIDA.
Well, I guess, Your Honor, then that's the reason for the reduction. And if the court is not going to accept that I understand. I just want to put forth that I believe under these circumstances that HIDA would be appropriate. And that's what we discussed.
Well, I don't know if you want to, I'm just letting you and your client know now that your client likely isn't going to be eligible unless you find some type of law that tells me that I have to find him eligible under HIDA, which I don't believe exists. So I'll give you an opportunity to speak to your client.
That's okay, Your Honor. There's also, as part of that plea, a disorderly conduct. So is that correct? You understand? You may not get HIDA because of the prior record. Yes, sir. Okay. Intentional.
Okay. Likely not. Just so you know, it's not a may or may not. It's a likely not going to be eligible under HIDA. All right, sir, please raise your right hand. Do you solemnly swear or affirm the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Are you picking him up, Ellie?
No.
Please be louder.
Yes, ma'am.
Perfect. Thank you. All right, and sir, you heard the plea that was placed on the record, correct?
Correct.
And as to the generous plea of an amended charge of disorderly conduct, how do you plead?
Guilty.
As to the amended charge of allowing a licensed driver to drive, how do you plead?
Guilty.
You've gone over your advice of rights with your attorney, correct?
Yes, ma'am.
And you understand all of those rights.
Yes, ma'am.
You also understand, sir, the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes, ma'am.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
And you do understand, sir, as we've discussed on the record, or as I've informed you on the record, that HIDA, while the prosecution may have agreed to it, is discretionary by the court. Do you understand that? Yeah. And then upon a review of your criminal history, I'm likely not going to find you eligible under HIDA, and this conviction will stand on your record. Do you understand that?
Yes.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
Counsel, if you can please pardon your client.
Thank you. Mr. Vega, on April 18th of 2026, were you in the city of Middleton? Yes. And did there come a point in time when police officers were calling out to you and telling you to stop, and you ignored their orders and entered into a bill? Is that correct? Yes. And then there was some more discussions, and they got loud, and you became disorderly during this process. Is that correct? Yes. Defense is satisfied with respect to that. Also, Mr. Vega, on that date in question, were you operating a motor vehicle? Yes. And at that time, did you have a valid operator's license to operate that motor? No. So you were allowing yourself to drive while unlicensed. Is that correct? Correct. And satisfied, Your Honor.
The court is also satisfied with me as knowing voluntary, and factually accurate, and the court will accept your plea to the amended charge of disorderly conduct, as well as to the amended charge of allowed a licensed driver to drive, and the no proof of insurance amended charge.
That's responsible. You understand that?
Yes.
Okay.
Thank you.
And sir, are you under the influence of anything this morning?
Oh man, I've been used since I've been locked up.
Very good. And so if you were to test right now, what's in your system?
There, a week takes 30 days to get out of the system. I don't know what your guys' test or the marijuana will come up in my system, but it'll be low.
Okay. And you've had no new use since you were in
No man.
custody. All right. And sir, where do you work?
I work at Freeman's Landscaping.
Oh, that's right. I remember the brothers all work together as well. Perhaps you may all want to distance yourselves because you don't seem to make good choices altogether.
It was, to be honest, Your Honor, I made the decision and I told my brothers to run, so it does fall on me. And next time I'm making a smarter choice.
Well, sir, to be honest, I'm not sure how many more opportunities you think that you should have.
This is my last opportunity.
You're correct.
I plan on coming back to the court and I'm planning on getting locked back up.
Well, I hope you plan to come back to court on your sentencing date.
I think he meant on another matter.
On new charges?
Yes, ma'am.
That's good. So how are you going to effectuate your plan? It's great to have a plan. Okay? It's great to have a plan, but how are you going to implement that plan?
I got my permit since I've been out and I will go take my driver's test this week or next week and I will have a license and I plan on staying and working, staying out of trouble and have my vehicle insured next time.
Well, that would be a good start also.
We discussed that, you know.
You would think having the felony on your record for fleeing and eluding, that would have been, your probation and the conditions that from probation that you would have had that learning experience in that regard. So, bond and conditions are continued. Please have a seat in probation. Somebody will be with you shortly. Okay?
Thank you.
You have a good day.
Have a good day is right. Oh my god. Well, discombobulated. Oh, I'm knocking things over. Oh my dear word, what's going on here? I don't even know. Hi. How you guys doing? I'm here. Ladies and gentlemen, that's all I got. It's been a long day today. And I scoured the court tubes and I pulled another 15 hours out from everything I had, but that was 2 hours of it. And while Rhonda's passing along that URL, let me share another little URL, because if you want some more court content, our little friend right here, not me, but Wolfie, the one who's supposed to be talking right now, yeah, he's streaming right now. I think Stevens is doing the Walker case back there. It's really an interesting case, and there's probably another good hour or two beyond that. So if you're interested in a little bit more court content while you're going over there and joining that new Discord that Ron put together, maybe check out some Wolfie bot, some Lone Wolf bot. Those are all videos from the archive. I think right now I'm showing May 13th of 2025. So 1 year ago today is on deck. Ladies and gentlemen, I have lots of people to thank tonight. Oh my word. The list just kept growing and growing and growing. Jody, Dixon, Marty, into Karen, Tammy, Julie, Allie, Mary, Stephen, Wendy. Did I get everybody? I don't think I got everybody. But I tried. Lord knows I tried. Wendy Greek, Stephen, Allie B, Julie, Tammy Tianki. There were tons more. All you people right there in that little list right there. I Can't read all your names. It's going too fast. You all rock, though. I just want you all to know. Hang around. You know, come back tomorrow night. I do this every single night. Same Wolf time, same Wolf channel. That's 8 p.m. Central, 9 p.m. Eastern. Whatever that is, in your own personal time zone. Figure it out. Ask your favorite AI. Get on Google. Do something like that. Ladies and gentlemen, it has been a pleasure pulling these cases together for you from all over the court tube today and getting them all in one spot. I got lots more of these to come. We got some more videos dropping at 4 a.m. and noon tomorrow. And then we got the weekend case, the weekend review coming up. And then I've got some big weekend premieres coming up. So get your like on, get your subscribe on, and do all those things. And I'm your Lone Wolf Usul. And I want to say thank you very much. And for now, I am out. You know, right here. Oh my. I guess Bella told us all. You know, right meow. Right meow. I got nothing else. We're going to watch more court. Right meow. Right meow. Right meow.